Welcome, listener, to the Legal Paige podcast. Today, I'll be discussing a topic that has been quite a discussion in the Legal Paige community on Facebook. And that's, what do you do when you send your contract to an inquiring client and then they come back with a ton of edits or red lines, or they ask you to change or delete some clauses? So this situation is one of those going to happen situations in your business journey. That's just the nature of working with clients. Everyone is so different. And it doesn't matter how good your contract is. You're going to run into clients who have thoroughly read through the contract that you send them. People who just like to dicker on legal language. We call these litigious clients here at the Legal Paige. Or you're going to come in conflict with clients who are lawyers and oftentimes just like to push back because they have a law degree. And you're also going to come in contact with clients whose, what I like to call third cousin twice removed, is a lawyer. They just say XYZ has reviewed my contract and they've looked it over. And now we have some issues that we would like to raise with you. So no matter what way you slice this issue, it is an issue that's absolutely going to come up. So I wanted to put on my lawyer hat for you all, as if I was your attorney and am now advocating for you in this position as the service provider. And I want to jump into all of the ways in which you can oblige your client, but also give you my biggest suggestions for holding your ground and not changing or deleting any important legal language in your contract that would actually really hurt you down the road. So let's chat more about this, Legal Pagers, in this episode. You're listening to the Legal Paige podcast, where we chat about life and business with a legal twist. I'm Paige, attorney and photographer helping online businesses and creatives tackle their business dreams without breaking out in hives. No more legal mumbo jumbo. This podcast features simple, bite-sized advice that'll have you legally legit in no time. Are you ready? Let's get started. As a reminder, before we get into this episode, I am legally obligated to give my disclaimer. I am an attorney, but I am not your attorney. All legal information I talk about in this episode is intended for the masses and a large variety of different businesses. Please seek out another attorney in your city and home state if you need specific legal advice related to your unique business. Okay, let's get back to it. Hey everyone, thanks again so much for tuning in today. This topic is one I've wanted to do on the podcast for a while, but it really seems like this particular issue is pressing and coming up for a lot of you right now. So I wanted to give you some helpful hints ASAP. First, let's just discuss when this situation would come up with a client. So when a client has read through your contract thoroughly, and now they want to make some changes, or they've sent the contract to someone else who may have some legal background. That's usually when this is occurring. This is not to say that your clients aren't thoroughly reading your contract every single time, but lots of times clients are just really, really used to scrolling through, kind of perusing the contract and then signing at the bottom dotted line. Those are the clients that are never really going to send you this email and have conflicts with your contractual language. It's the ones who have read through it, had time to process it, thought about changes that could be had in the contract, and then inquire back with you before signing the bottom dotted line. And then you're also going to have clients who either have a legal background or they know someone else who may have a legal background. And when I say may, I want to be clear here that I oftentimes think that clients are just giving some pushback. Like maybe the person that's reviewed their contract is in law school. Maybe they desire to go to law school. Maybe they are a lawyer, but they're not even a business or transactional lawyer, and their expertise is in like family law. So all to say, this lawyer, quote unquote, that may have read their contract and is now somewhat representing them and is inquiring about changes, either they are as the lawyer on behalf of the client, or usually what happens is the client is saying, I've had XYZ look through the contract, who has a legal background or is an attorney, and we are requesting some changes. So that is when this situation is coming up most often. Those two circumstances. You have clients that just want to make the changes themselves and have read through the contract. They're either litigious or they like to redline things, or they just like to take up issue with contracts for whatever reason. People can do that. It's their own prerogative. Or they've probably sent this contract to someone that at least has somewhat of a legal background. Here are some things to remember when this situation comes up, okay? You are the company they are hiring. Your policies go. And your contract is there to protect you and your business. So yes, I always say, if you've listened to other episodes on the Legal Paige podcast, contracts should have rights and responsibilities for all parties involved. You don't want a completely unilateral, one-sided contract. But contracts that you send on behalf of your company are always going to be more heavily cited to protect the owner of the business because it's your contract. It's not the client's contract. It's your contract. And you have to remember this. Please remember this. Your clients should be in agreement with your policies if they want to work with you. I know that's hard for many people who are just starting out. If you're a newer business owner, booking a client is really important to you. And I know that you are probably listening to this episode and you're thinking, but Paige, I don't want to lose out on booking this client if I don't want to work with them or change the contractual language that they're requesting. If you are in that position and you're a newer business owner, just remember that letting go of one client is not the end of the world. And actually letting go of a seemingly difficult client can actually be good business sense. Now, if you are a seasoned business owner, you know what I'm talking about. You know these difficult clients. You know that oftentimes they're just trying to be heard, right? Some people just want to be heard, you guys, and they just want to have a discussion with you. And oftentimes the issues they bring up can be resolved by just talking with the clients and clarifying those sections in your contract so that they can understand why it's written that way. And many of you that are seasoned business owners are probably shaking your head and saying, yes, Paige, that's usually what happens. And also probably seasoned business owners are like, I'm okay with letting go of a red flag client. I like to call these red flag clients. However, potentially they're more orange flags. And I want to get into that more in this episode regarding like some of the clauses that you may be able to modify. So I don't want you to have like complete red flags coming up. But I think seasoned business owners truly understand that if clients are if they're just asking for a couple things or clarifications to a contract, or they're asking to modify clauses that you know can be modified, then you're like, okay, cool. This is more of an orange flag client. I'm going to satisfy their needs. I'm going to talk with them. We're going to resolve the issue. We're going to move on. They're going to book. Everything's going to be fine. When I say red flag clients, as you work through your business journey, you will understand the difference between these orange flag clients and red flag clients. And I see all the time in my Facebook community, it's called the Legal Paige community on Facebook. If you guys want to join, you totally can. And we have people that respond to people's posts when they say, hey, my client responded back. They want to change XYZ. Like, what would you guys suggest as a response? Or how do you guys approach this situation? And lots of people in their comments and responses are saying, red flag, don't take on this client. I don't think that's necessarily true. And that's why I really wanted to press upon this topic right now in this episode, because I truly, like I said, believe there's a difference between a massive red flag client and people who just may be more inquisitive or are orange flags, and they just need a little bit of hand-holding through signing the contract in order to be comfortable with, say, paying you $5,000 to $10,000. Like, that's totally reasonable. Okay, so now, if the situation comes up because they've sent it to a lawyer, quote unquote, however way, shape, or form that lawyer is a lawyer, sometimes just be aware that those lawyers just want to puff their own chest a little bit. And they are trying to your clients are trying to have a little bit of more power or sway over you by honestly just stating the words, I've had my lawyer review this, or my dad is a lawyer and has reviewed this and we have these changes, or My cousin is, a transactional lawyer and read through my client for me, and he suggests these changes. I'm just going to pause here and be like, usually it's he has read through the contract. I would love it if one of these emails says a she read through it. Okay, I digress there. But all to say, don't let those lawyer dads bully you into changing your contract. Don't let them just have power over you by saying the word lawyer, okay? They probably aren't actually lawyering for them and representing them as clients. That would be a lot of money for them to do. They are probably they don't know. They're signing a big contract. They're sending it to someone that they know that actually has some type of legal experience and can better adequately read through the contract and give them some suggestions. But here's my point. These lawyers know it's your contract. Like, they know that. They know you're the service provider. They just know that there is negotiating power between parties to a contract. They've learned that in law school, even if they haven't ever done contractual law later on in their legal experience as a certified attorney. But they do have some background from taking the bar exam and doing a contracts class in law school. And they know that they have the ability to ask for modifications, to ask for changes, to negotiate. We all know that as lawyers. So that's what I mean by sometimes they just want to say they're a lawyer and try to input some changes and see if they fly. But at the end of the day, that's not how it works. They know it's your contract. They know you're not going to budge on a few things. They're probably just trying to try for their friend or daughter or cousin, but they know it might be an uphill battle to get you to say yes. So there's that. Also, I want you to remember that good customer service does not equate to changing your contract. Don't let yourself fall into that trap. It's actually quite the opposite. If you let your clients dictate your working relationship with contract modifications before they even book you, and they're finagling you into modifying some of your policies, now I think that's a huge, huge orange or red flag for them being challenging clients in the future. Now, I say orange or red because I think you'll know. I think you'll know after a couple back and forths of communicating with this particular client or clients, if it's two clients hiring you, like spouses for a wedding or event, then, if they're demanding more things from you or they're not in agreement with one minor change, but you're not willing to change on the other things, that leads them to being more red flag clients for them, more likely to bring up contract issues in the future, demanding more things from you, being extremely litigious and taking you to court down the line. That's what I mean by red flags. Orange flags, again, are just, okay, maybe they just want to be heard. Like I said, maybe they just want to have the discussion. I don't want you to just, though, give it all to them on a silver platter. That is the customer service I don't want you to be privy to. Because I ultimately think being a good customer service representative for your business simply means hearing them out and then being professional in your response and understanding what you can budge on and what you also should not budge on. So let's get into that, okay? First, here are the clauses I never want you to budge on. Your fees clause, right? I'm sure you're saying no doubt, Paige. Your fees clause is how much they should pay, when invoices are due. Are there any late fees attached? What happens if they don't pay in time? All of that needs to be in your fee clause, and that should be non-negotiable. Also, your rescheduling and cancellation policies. That is what you have set up for your business in order to adequately serve other clients, in order to be able to mitigate damages and book other clients if, say, they were to cancel or reschedule. Those policies should not change. And again, I want to just pause here and say, those are your standard rescheduling and cancellation policies. I'm going to get into what you could make a minor adjustment to regarding COVID reasons for rescheduling and cancellation. But your general rescheduling and cancellation policies, please don't budge on. Next is harassment and safe working environment clauses. Okay, these are really important and are there to protect you. This issue recently came up in our Facebook group where someone posted, my client would like me to change my harassment clause. Okay, for me, that's a red flag client, not an orange flag client. I'm like, why in the world would they want to change your harassment clause? A harassment clause, you guys, essentially says, if I get harassed as a service provider, I have the right to terminate my services at no fault and be able to leave. Like, you as the clients need to keep third parties and guests at your event or whatever under control. And if I get harassed, I shouldn't have to subject myself to a second harassment situation in order to leave. We have one strike rules here at TLP for all intensive purposes. I myself have experienced harassment at weddings and events, and it is so uncomfortable to have to stay and perform services when that type of thing occurs. So I believe in one strike policies. I also think that this is so important for you to explain to your client. Like, if I get sexually assaulted, I'm going to leave. Like, that type of harassment is not okay. But if I also have the ability to kind of notify you. This is called the 2-strike rule. And some people, if you want to modify your clause to be a 2-strike rule, okay. I don't suggest budging on it, but if you're comfortable doing this, then you can. Where it's, if I get harassed, I will notify the client. You have to take initiative to get this harassment to stop or get this guest to leave or get this vendor to leave. If you don't and the harassment occurs, then I can terminate my services without any further liability. That's a 2-strike rule. If you're comfortable changing it, okay. I don't suggest it because I don't think that anyone should be put in a situation where they have to be harassed twice in order to terminate services. Okay, I'm going to stop there. So that clause is really important. And I want you to question why a client would want that clause removed or changed. Okay? That feels like a lawyer puffing their chest there. Literally makes zero sense. That clause is there to protect you. Same with a safe and working environment clause. So these type of clauses are, you have the right to reschedule, you have the right to change locations, you have the right to not go into a dangerous situation, such as doing photography at a location where there are wildfires, and the wildfires could move swiftly and quickly and make it very unsafe for you to get there. Any quarantined areas that you have the right to terminate services if, a firearm presents itself during the services, a concealed weapon is there. If your clients are asking you to do anything illegal that is unsafe, that you have the ability to leave or terminate services, though that clause is there for those specific purposes to protect you so that you don't put yourself in a situation where you can't leave because you're uncomfortable, because your clients are doing something illegal. Just that clause is non-negotiable as well. Okay, there are also specific clauses related to your business that I never want you to budge on. For photographers, if you're tuning in, this would be like your delivery of images clause, your editing clause, posing, artistic style, reproduction clause, etc. For wedding planners, it's going to be planning calls, how many trips you'll do back and forth from the venue, mood boards, when the client can or cannot change the theme or style of their wedding. You're catching my drift here. These are the specific clauses related to your business that you would never budge on. And to be honest with you, your clients are probably never going to ask for you to change. But I just wanted to put that in here. Other clauses, permits or third-party vendor liability clauses, clients' responsibility to insure themselves and secure insurance. So all of those clauses are very much there to ensure that onus isn't put on you as the business owner. So your clients are required to get the necessary permits. Your clients are hiring these third-party vendors, and you have no attachment to them, so you should not have any liability for anything they do. And that, of course, if there was any mishap or circumstance that prevented the event from happening beyond the parties' control, that they've secured necessary insurance to compensate them for such situations and that they can't ask for a refund in those situations. That's on them. So those clauses, again, are there to protect you. Don't budge on those. The other clause that has recently come up in an inquiry here at TLP is a client asking to change an inclement weather clause because they feel that they shouldn't be responsible for inclement weather. But my response to that is, well, neither should you as a business owner. And your clients are the ones deciding to do XYZ outdoors. They should be the ones taking on that risk, not you. So, for example, a florist was getting some pushback from a client regarding their inclement weather clause, which says the florist will inform the client of all necessary, procedures that they need to take to ensure that their floral arrangements stay intact throughout the day. If it's hot out, if it's rainy out, if it's cold out, if there's wind, if there, is a severe weather warning, the florist is going to look into those things and should properly notify their client of XYZ potentially occurring. And then the inclement weather clause says that the clients have the right to either move their floral arrangements indoors to stay protected in humidity and air-controlled environments, or the clients can choose to continue to host their floral arrangements outdoors, and they're accepting the risk of doing that. And then this clause goes on to state that the florist, when they leave, so they go to set up these floral arrangements, and then when they leave, and if the client chooses to have these outdoors, particularly this was for an archway for florals at a ceremony location outdoors, the client had pushback saying, well, if you leave and then something happens to the florals, I want you to come back and adjust the florals and make them right before the ceremony if inclement weather were to do this. And the florist was having a really hard time being able to have anything to say back to the client other than, wait, what? Why would that be on me? So that's why an inclement weather clause is really important to have, because in this situation, the florist was setting themselves up for success by having such an inclement weather clause, and the client was wanting to adjust it. And this is one I would never budge on, because you should not be at risk for florals at an outdoor ceremony location once you leave. That risk should be on the clients. And if something were to happen, you guys, I have even been at a wedding where this occurred, now that I think about it. Oh my gosh, I'm having flashbacks. It was a seemingly perfect day in Montana. If you don't know, I live in Montana, and we have lots of bipolar weather, which is what we like to call it here in the summer, where it can be perfect out in July. It could be 85, 90 degrees, no wind, amazing. And then this massive thunderstorm comes through in the afternoon. It's over in 45 minutes. There's a beautiful rainbow, and then it's beautiful and sunny again for the rest of the evening. I remember this at a wedding when the florist came, set up this beautiful arbor archway at the ceremony location, and then this huge gust of wind and thunderstorm came through, and the archway fell down. And of course, my clients were going to call the florist and be come back up here. This is your fault. No, their friends and their family and moms and aunts and everybody put the archway back up. And then they all started putting in the florals themselves to try to get it back to the way that the florist had it. So you as a service provider can only be responsible for what you are in control of. So an inclement weather clause, that was a long-winded answer and story for you all, is one of those non-negotiables. Ready to build a legally legit business? Become a Legal Paige Insider and get exclusive access to all the top-notch resources TLP has to offer. As a TLP Insider, you'll get insider access to all of our sales and promotions, also known as better deals than anyone else. First dibs on freebies and legal classes that will help you legitimize your business and step into your role as Chief Legal Officer. Jam-packed weekly newsletters so you're always up to date, and our unique perspective regarding the most pressing legal issues facing biz owners today. So to become an insider, just head to thelegalpaige.com/TLP Insider. Again, that's thelegalpaige.com/TLP Insider, all lowercase. And now let's get back to the episode. And finally, any other boilerplate or miscellaneous clauses in your contract, including force majeure clauses, limitation of liability clauses, maximum damages, entire agreement, arbitration, mediation clauses, severability, no waivers, transfer clauses, etc., are non-negotiable in your contracts. Now, here are some clauses that you could make minor adjustments to if you wanted and your clients are requesting. I'm going to give you some specific examples here on when you should do this. So rescheduling and cancellation clauses for COVID reasons only. So say you have our acknowledgement of COVID clause and no rescheduling, and that's what you put in your contracts. Potentially, you have a client situation where it's kind of like a no holds bar for you now with, COVID rescheduling and cancellations. You're just going to treat them like any other rescheduling or cancellation situation. And that is the legal language that you put in your contract with such a clause. But then you have some clients giving you some pushback a little bit, and they are, say, international clients. So they are traveling from a different country. They are still unsure. Maybe they have had different openings of their restaurants and businesses and being out of stay-at-home orders very differently than you have here in the United States. And it may be hard for you to kind of step into their shoes and see where they're coming from. But potentially they are very, very concerned about potentially having to reschedule here in the next year since things are just starting to open up where they are. If they're in that situation, maybe just hear them out and be willing to make one potential change to your contract regarding just rescheduling, that they wouldn't be able to cancel the contract. If they canceled, they'd forfeit all fees paid. But if it's for a COVID restriction on travel purposes and say that's exactly what your clients are worried about, then they're not asking you to change your entire policy. They're asking you to just make a minor caveat to the clause for if any travel restrictions were in place for them and they did need to reschedule. You can craft this language and tweak this clause to be so specific just for these clients, right? You can allow them a reschedule in that situation that you would transfer all fees, but you do have to implement a rescheduling fee, say of like $500 for your time and efforts into rescheduling the entire event and then trying to book someone else on that date. But at least they're not out all their money. So it's kind of coming to a mutual understanding in that scenario. Hopefully that makes sense to you on when I would suggest that you could potentially change your rescheduling and cancellation clauses just for COVID reasons. I do truly think that this is going to continue to be an issue, at least for the remainder of 2022. If clients are giving any pushback on it, just listen to them and figure out what they are most concerned about and how you could potentially modify your contract to serve them and their concerns, but also still protect you so that you're not just like out that event date and out a bunch of money as well. Next, indemnification clauses. So this is a clause that if they do have like a lawyer looking at their contract, we are trained as lawyers to negotiate indemnification clauses. And a lawyer is absolutely going to puff their chest and try to get you to modify an indemnification clause. Honestly, these are smart clients if they're asking you to change an indemnification clause. Even if they didn't say they had a lawyer look at the contract, and even if they're just reading it thoroughly and then asking for changes, I would never say those are red flags. I truly would never say, this client is never going to be my client. They're going to be just a pain in the arse for the rest of eternity because they want to change my indemnification clause. No, 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 no. Indemnification clauses are honestly there to shift liability from party to party, or if a third party were to come in, then one of the parties would kind of indemnify and hold the other party harmless. So we draft them here at the legal page as the client indemnifying you as the company for any third party claims. There are too many laws and case precedent out there regarding the fact that you cannot indemnify for your own negligence. Now, this is very state-based, but all in all, across the United States, it's just not good to indemnify for your own negligence. There are such narrow circumstances that you can do this. All to say, you guys, that these indemnification clauses can easily be negotiated to be mutual indemnification for the parties. We only draft our indemnification clauses here at TLP, like I said, for third-party claims. So if your client is reaching out to you saying, we're not going to agree to this indemnification clause, you can't indemnify yourself for your own negligence, blah, 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 they are probably reading that clause wrong and didn't read it as it is only pertaining to third-party claims. So maybe just first point that out to them. Second, if you have a previous TLP contract, we had longer indemnification clauses in our previous contracts, like 2019 through 2021. Last year, we started to realize that these longer indemnification clauses, albeit I and my legal team thought it was better to have them more thorough, more, clear legal language. They were a little bit longer. It actually ricocheted for us, and clients ended up having more concerns surrounding the indemnification clauses. So since then, last year in 2021, we changed our indemnification clauses to be more succinct, more clear, not so scary of a clause. There's no other word I can really use to describe that. Not all up in your face for clients to look at and be frightened by. It's just like a simple indemnification clause that says clients agree to indemnify and hold company harmless for blah, 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 blah regarding third-party claims. If you wanted to change that and your clients were giving you pushback, you could just change it to a mutual third-party indemnification clause. So that would say, all parties agree to indemnify the other parties from third-party claims, so on and so forth. So it should be easily adjustable on your end. We also have a bundle of indemnification clauses that we sell a la carte at thelegalpage.com if you're interested in kind of having other options if clients are asking for pushback or are asking for changes regarding your indemnification clause. So like I said, that one is totally negotiable. I think that's the most negotiated clause in a contract, and it's okay if people are inquiring about it. Okay, next is a venue and jurisdiction clause. This one you could make minor adjustments to if you wanted. I'm going to give an example here. So perhaps you're from Colorado and you're performing services, say, in Florida. So you're like a traveling service provider. Maybe you're, a hairstylist. You're going to an event in Florida, but the client is coming from New Hampshire, okay? You're from Colorado, event is in Florida, client is from New Hampshire. Maybe in this situation, you both mutually agree to a venue if something were to happen, legally speaking, and you needed to go to small claims court or you needed to go to your district level state court. The venue means where would that occur? What venue would that happen in? And the venue is just the location. So it's the county and the state of where that litigious situation would go down. Maybe you both hear in this situation, it would be better for everyone involved to just mutually agree to Florida to resolve the disputes, the county that this event is happening in Florida. Because if something were to happen and you and your clients weren't okay with you putting Colorado as your venue down, your county in Colorado, I understand from a client's perspective, that seems kind of unfair. They're from New Hampshire. They would have to come all the way to Colorado. Maybe it's just kind of you scratch my back, I'll scratch yours. Let's just both mutually agree to Florida. But All to say, most often, a venue and jurisdiction clause should always, always, always stay your home county and your home state as the business owner, even if you're traveling. There's just a small percentage of situations that I would suggest if you are getting, some pushback from a client or your client just isn't happy with that being the venue, and they will sign the contract if you just change it to Florida. Like the likelihood of the lawsuit even going through would never occur. You'd probably just settle it, right? 97, 98% of cases settle. So you're probably not even going to get into Florida. But just remember, this is a small percentage of times I would ever suggest you modify it. The only other thing is jurisdiction in these types of clauses. So I talked about venue. Venue is like where the actual dispute would occur, like what county and state courthouse would this be heard in front of? Okay. Is it small claims court? Is it a district court in your county? I also want you to be aware of the jurisdiction part of this clause. And jurisdiction means by what state's laws will this contract be interpreted by? You might not believe it, but you can totally have a different venue than jurisdiction. Oftentimes they're the same, okay? So I live in Missoula County, Montana. I will always put Missoula County as my venue, and I will put the state of Montana as the jurisdiction that my contracts are interpreted under. Montana laws. You could have a venue in Florida and the contract will be construed under Colorado state laws. The reason being is if you've had your contract written by or reviewed by a lawyer in your state, then the jurisdiction should most certainly never be changed and should be your state because those laws are applicable to how the lawyer wrote or reviewed your contract, and you wouldn't want it to be invalidated by having some other state laws apply to your contract. So always, always, always try to keep your state laws as the jurisdiction, and you might be able to negotiate venue under limited circumstances with your clients. Hopefully that clears that up. Next, intellectual property clauses. Usually, you guys, these are never negotiable, okay? Some of you probably are raising your eyebrows and being like, Paige, my copyright clause is non-negotiable. These are my copyrighted images or my copyrighted films and videos, my copyrighted works. If you're a website designer, like these, that's non-negotiable for me. But I put this clause here under something you could make minor adjustments to if you wanted, because say you're doing branding services for companies. Usually there is some type of release for like limited commercial use caveats for your clients using your copyrighted works, okay? So this is, again, a limited circumstance that an IP clause would be negotiated, but sometimes they are, and especially for like branding shoots, branding videos, if you're performing services and you're doing brand design for a client as well, and you're maybe holding on to the copyrights for those works, but then you're allowing them like a limited commercial use to be able to use it on their own marketing and advertising, blah, blah, blah. But you still want to own the copyrights for you to be able to sell any derivatives of those works to others in the future. So say, for example, you make a website design for your client. That particular website design is going to be released to them under limited commercial use that they can use it only for their business. But you as the website designer may want to tweak that or use elements of that website design for future clients in the future. Of course, you're going to completely take off their branding. You're going to make significant alterations to that. But you don't want to just give them all of the copyright and intellectual property ownership over their website design. Because say you need to use that for third parties or additional clients in the future, you still want to own the full copyright, and you're just giving them and assigning a limited commercial use for those purposes. So that is how I would negotiate that clause if your clients are inquiring surrounding, like how can we use these images, or for photographers and videographers, usually it's just like a straight up personal use. ability to use the images, and you own the copyrights to all of those photos. You're the only one who can reproduce those, who can publish it, who can give it to third parties, so on and so forth. So just be clear with your clients on who owns the copyright of what, and are there any limited circumstances that they could use those for commercial purposes, anything that's copyrighted. I also wanted to briefly talk about here model release clauses. This comes up time and time and time again, where you have a client who likes their privacy. That's okay. They can like to be private individuals, and you have to be respectful of that. There's really two avenues here, I always say. You can adjust a model release clause, and if clients are giving you pause on the model release clause and they don't like it and they're private individuals and they want you to change it, I always suggest jumping on a call with them instead of like emailing back and forth, and just really hearing them out human to human and understanding where they're coming from. Why are they private individuals? What is happening? Are they in government? Do they have do they have actual work reasons why they aren't able to have their faces shown? Are they just private? Is there a way that you can negotiate it where maybe you could use their photos for maybe like some purposes, but not all? Maybe they'd be comfortable with that. Maybe you can use photos of their event without their faces in them. There's multiple ways here that you can address any client confusion or client hesitation surrounding signing an all-inclusive model release that you have in your contract. Now, you can do it. You can do it without pay. You can, just oblige your clients and completely change the model release or take the model release out. I often say you change it to kind of a client's privacy clause, and you address their privacy concerns and what you cannot do with their photos or videos or however you're servicing them. That is what I would do. I would not put it as a model release clause. I would change it to a client's privacy clause, and how you as the company are going to be respecting that. And you can just write that out yourself. There's no like massive legal language you need to put in there. I also understand that there are business owners out there who truly believe that the package and price that they have for anyone who inquires to book with them is based upon the fact that they can use those images for future, marketing and advertising efforts. And that if a client is asking to keep things private, they now have less marketing and advertising materials, and they feel like their price should be reflected to incorporate that. If you're in that boat, I understand. And then you just need to have kind of standard operating procedures in place for how you're going to communicate that to your client. Say that you're totally willing to take the model release clause out and put in a client privacy clause, but because you aren't able to use their photos or whatever copyrighted works you have under this agreement and have actually put together for the client, if you choose to be private with these images, say, I'm going to use that as an example here, then we do increase our pricing an extra $500 or an extra $1,000. That's your right. That is your prerogative as the business owner to do that. You just need to be aware that like clients could feel weird about that. I, for one, am totally fine with clients wanting to be private. I think it's everybody in the world has the ability to keep things private. And in a very non-private world that we live in now, people are just becoming more and more strict with their own personal privacy, and maybe wedding images or I don't know, whatever videos you're taking or copyrighted works you're creating for them. They really want control over that staying private versus giving you all the control and under an all-inclusive model release. And you just have to really talk through your clients with that and figure out what's going to work best. Are they going to be okay with you upcharging for not having a model release? I will end this discussion here with saying it is very common in celebrity contracts to have massive, massive, massive charges for assigning copyrights over to them. And so I think lay people, non-celebrities don't fully understand that this is commonplace when negotiating contracts. They don't want you to have a model release. They want you to assign the copyrights to them so that they can go get published in like People magazine or something and make $1 million. But that if they own the copyrights, now you own nothing if you're the photographer in terms of getting paid royalties or any type of payment for People magazine. So you upcharge to kind of offset that balance of, power and cost there. So usually professional photographers who are releasing their copyrights and they're not having a model release, and there's probably an NDA involved in those contracts as well. Those celebrity contracts are upwards of 30, 50,000 or more, because those people can certainly pay for your services if they are going to get paid hundreds of thousands of dollars from a magazine to publish those photos. So just be aware that this is commonplace in, multiple other industries, that people do ask for privacy, that it is okay to get paid to take out a model release clause. But it's also totally fine if you just have every run of the day clients and you just want to fulfill their privacy concerns and needs, then it's okay. Just be okay with them being private. Don't charge them for it and move on. Finally, exclusivity clauses. These are types of clauses that you see in business to business contracts usually. So not so much your client pushing back on you like an actual average day, everyday person that's hiring you for your services, but say you're an online coach or you're a website designer or you're a lawyer, for example, working for someone, and you want to have exclusive rights for them to only utilize your services for a certain period of time, that they agree to only work with your company. Those are clauses that are oftentimes negotiated in contracts. Usually you present them with kind of the most stern exclusivity clause, and then you can negotiate to figure out mutually what would be agreeable by both parties. Maybe the exclusivity isn't for a year. Maybe it's for 6 months. Maybe you broaden the range of the exclusivity. So say you're working with a website designer and they're designing your website, and they potentially want to work with different brand strategists, which is different than the website. Maybe you broaden that range of, okay, I won't work with a different website designer for a year, but you will allow me to work and modify my brand over the course of this year, as long as I'm not modifying the actual majority percentage of the integrity of the website, so to speak. So you can negotiate exclusivity clauses to that effect. Moving on, I wanted to give you some examples on how to address these kinds of situations to your clients kindly. So I've talked about here when this situation would come up, the clauses that I don't suggest you budge on, and then some clauses that you could make minor adjustments to if you wanted. When a client is asking for changes to non-negotiables, I don't want you to just start with a big NO. Don't just say no. I want you to ask them why they are concerned about those clauses. Maybe there's a way for you to put them at ease before telling them kindly that those clauses are not going anywhere. Maybe you don't just start out being harsh. I think the more professional way to approach this is, again, to listen to your client's concerns, absorb them, and then be able to explain to them how this clause does protect them, but it's also mainly there to protect your business in XYZ circumstance. Oftentimes when they're hearing that from you as the business owner and you professionally really, truly understand the clauses in your contracts, they will absolutely agree to keep it in there once you explain to them that you know why it's in there and why it's there to protect you. Another helpful tip here is, once you get some more information regarding the client's concerns, see if you can address some of their issues in another clause that could have some wiggle room, like the rescheduling clause for an indemnification clause. Those are different ways that you can address a situation and kind of ensure that your clients feel like they still have a little power, but instead you're just maneuvering another clause, but keeping the clause in there that's really non-negotiable. Sometimes that's a great way to do contract negotiation. And in most cases, my friends, clients just want to feel heard and acknowledged for their fears. If they continue to push and nitpick your contracts, that's when maybe you should look at cutting ties early on, or they're moving from an orange flag client to a red flag client, and you really need to start putting up your walls a little bit, and you need to start holding your ground, and you need to say, no, this is a non-negotiable. If you don't sign, I'm sorry, we're probably not suited to be good fits to work together. All of that to say, I really hope that this episode answered the majority of your questions and concerns regarding what you can change in your contract when your client asks and what you should never touch. Please, please, please feel free to reach out to myself or my legal team with any concerns or questions that you may have regarding this type of situation. You can do it in the Legal Paige community on Facebook that I've talked about previously in this podcast. You can also find me on Instagram. I'm on YouTube as well. Or you can simply email us at support@thelegalpage.com. Thanks so much for tuning in, and I'll catch you in the next episode, my friend. Thanks so much for listening to this episode of the Legal Paige podcast. See, I told you being legally legit isn't so scary. Be sure to visit thelegalpage.com for all show notes. And it would be super awesome if you could head over to iTunes and leave a review. Last but not least, don't forget to join my free Facebook group for unlimited legal and biz Q&A. Chat soon, Legal Pagers.